This case concerned a solicitor named Whitman who ran a firm called Simon's Solicitors. In that capacity, he hired an employee named Robert Allen. Mr. Allen had completed his law studies and had been admitted as a legal practitioner, but had not yet obtained a practicing certificate. Regardless of this, he began doing work for Simon's Solicitors, officially as a receptionist, but actually as a solicitor. In fact, it was all so brazen that he actually appeared in the High Court twice. Eventually, it all came unstuck, and Mr. Whitman was the subject of an action by the Law Society. However, when the Law Society asked Mr. Whitman for documents and asked him questions, he essentially refused to cooperate and gave answers which were false and were designed to communicate a less than frank answer to the inquiries of the Society. The Solicitors' Complaints Tribunal, as it was then, imposed penalties on Mr. Whitman, but did not strike him off. This pleased nobody. The Law Society appealed to have him struck off, and Mr. Whitman cross-appealed to have the negative findings set aside. Chief Justice de Jersey, in the Court of Appeal, found that solicitors are under a positive duty to assist the Law Society in its investigations. In fact, they are required to be candid and honest in those investigations, even to their own detriment. There's no equivalent to a right to silence in these types of investigations. The Chief Justice said the respondent was generally uncooperative with the appellant and apparently took an unduly combative approach before the tribunal. Neither the investigation nor the hearing is criminal in nature. It is a process directed towards protection of the public, recognising that a practitioner is duty-bound to cooperate reasonably in the process. However, the court found that there was no basis to disturb the tribunal's findings, and so ultimately neither the appeal nor the cross-appeal was successful. From this case, we learn that a solicitor who is under investigation in relation to professional conduct or unsatisfactory professional conduct is under a positive obligation to comply with those investigations, including by answering any questions honestly and fully, even if the result might tend to be to their own disadvantage.